Alex here with part 148 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I always glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We go into my ex's attorney's motion to be relieved as attorney of record. She is ready to move on. She no longer wants to represent my ex. I think she cites concerns with regards to my ex's ability to pay, but I have a feeling that my ex had this issue long before this particular motion was filed. I think that especially considering how much money she was owed. And we're not going to see that until we get to the exhibits because I haven't memorized it, but I know it's somewhere around $14,000. It's not like she just suddenly owed $14,000. It's likely that for years she owed that lawyer thousands of dollars, and the lawyer just felt bad for her, didn't want to let the case go, thought she was telling the truth. And I think that at this point in time, the lawyer has realized that her client has been basically abusing her generosity. Not only has she been not paying her, but she's also probably starting to realize that my ex is actually the problem parent in this case, that she's not a victim of a litigious, harassing ex, but that she's committing serious abuse and neglect. I can remember a few stories from insiders, insiders as in insiders, people who worked in our law office. They didn't tell me details, but they did tell me that my ex's attorney was very unhappy with the fact that my ex had used a spoon or a spatula, whatever it was, to discipline her son. I wish I could remember more details. I just can't remember any more details. In fact, I'm only even barely able to remember where I met this particular staff member. I think it was like at a Kinko's or something, where I was copying papers. Anyway, I think because of how little I can remember about that interaction, and I want to avoid speculating. I don't want to guess. I really think at this point in time, most of this video is going to be going into the actual document itself. I do want to mention that my mindset was good. I felt like the case was just getting easier and easier. I was expecting my ex to have an attorney. I was expecting to not have one. Next thing I know, I do have an attorney, and next thing I know, she doesn't. So my mindset was obviously positive, not because I was sort of glad that my ex was disadvantaged, but because of how I planned the case from the beginning. I planned for the worst case scenario. I planned for the absolute deck being stacked against me and having to go and file an appeal. And even though I had planned for the worst, here I was, and it wasn't anywhere near what I had planned for. And I mean, as I mentioned earlier, I did have a lawyer. My ex didn't have a lawyer. Everything was going well in the case, at least thus far. So yeah, I think we can go ahead now and jump into what my ex's attorney has filed. Here we have my ex's attorney's motion for order to be relieved as attorney of record. She is indicating that as the attorney for my ex, she is requesting leave of the court to withdraw as attorney of record in the above captioned action, and she is making the request pursuant to Supreme Court Rule 46 and also the Rules of Professional Conduct, specifically 1.16. Points and authorities. The Supreme Court rules provide, it's funny how now that she wants to get off the case, she goes and cites all these statutes and rules. I mean, where was this when she was filing the opposition to my motion? Or both motions, not even just one, both motions. It was like no points and authorities anywhere. Now she wants to get off the case, and all of a sudden the law comes out. Anyway, Supreme Court Rule 46 subsection 2 allows an attorney to withdraw from a case upon the order of the court. And Rules of Professional Conduct 1.16 subsection B provides that a lawyer can withdraw from representing a client if withdrawal can be accomplished without material adverse effect on the interests of the client, and the client fails substantially to fulfill an obligation to the lawyer regarding the services, which is basically code for she isn't paying. In the present case, my ex has failed to substantially fulfill an obligation to the lawyer regarding the payment of legal services that have been provided. More specifically, it has been over 5 months that my ex has not contacted the lawyer to arrange for a payment plan to address the amount owed for representing her in this matter. And then she provides Exhibit 1, which is going to be a billing statement. We're going to take a look at that. As stated above, my ex has failed to fulfill the terms of the retainer agreement that she signed on September 1st, 2008, and then she provides a copy of the retainer agreement. The attorney sent an email transmission to my ex addressing the outstanding balance due. She provides these emails as Exhibit 3. Next assertion is that it is extremely unfair to the lawyer to be literally forced to provide legal services and fees and to pay staff and runners without being fairly compensated for the same. It is also extremely unfair to force the lawyer to pay the staff and runners while continuing to do work for my ex for free. The undersigned simply cannot continue to finance this action and should not be forced to do so. The lawyer is submitting that my ex will not be materially prejudiced by the court granting the instant motion. She can appear on her own behalf at any hearing that can be scheduled, and she can retain a new lawyer to represent her if she feels she so chooses. Conclusion. Based on the foregoing, my ex's attorney is asking permission from the court to be relieved as attorney of record for my ex. And here we have the certificate of service by electronic. So it looks like she's electronically serving my attorney and she is serving my ex by mail. That's what she's indicating. And that's all under Rule 5. Next, we have the motion opposition notice, which indicates that this is a free filing. She doesn't have to pay a $25 filing fee. Next, we have 3 exhibits. Exhibit 1. This is the bill. Okay, so $6,000 was the opening balance at March 31st, 2010. And then you can see all these fees are being added. She's being charged for corresponding again, drafting documents, filing documents with the court. Pretty standard stuff. This isn't a legal document. It's a bill. I mean, if you guys are interested, you can look through it. And if you have any questions, you can post those questions down in the comments below. As with my previous videos in the My Docket series, down in the description below, you'll find the links. You can click on those links and that'll allow you to download the full document for yourself so you can read it at your leisure. Here's another section. These are $250 charges. Here's another section, a lot more billing. Here's another section with even more billing. Lots and lots of billing here. Again, guys, this is not really a legal document. It's just a bill. We can all read a bill, so I think it's better for me to just glaze through this. Okay, so it looks like $20,000. Oh no, okay, I see. So $20,000 was what was, wait, is this what's due? $20,000 is what was due, but it looks like some payments were made. Okay, so after the payments have been made, then the balance dropped to $12,000. So I was pretty close. I was $2,000 over. She owes the attorney $12,000 in attorney fees. Exhibit 2. Here is the non-refundable retainer agreement. Anyone here who has signed a retainer agreement with a lawyer will know what this looks like. Again, this isn't really something that I want to spend a lot of time on for this channel because it's mainly representing yourself. It basically says that my ex paid a $1,500 retainer to hire this attorney, and then it has here the hourly rate of $250 an hour. And then I guess the paralegal gets charged $100 an hour. I don't have a whole lot to say about retainer agreements. I mean, I've talked about hiring an attorney in the past a little bit. I didn't spend as much time on it because really, I mean, high conflict child custody, most of us can't afford an attorney. This is like something that goes on and on forever and ever and ever, and it's mainly about representing yourself. So I don't really think that there's anything in this retainer agreement that jumps out at me as alarming. I think it's pretty standard. You pay money up front, and then you pay an hourly rate, and that's pretty standard. So Exhibit 3. Here's an email. The paralegal is saying to my ex, 2 weeks ago, emailed regarding payment. You said that you would make a payment when you got your tax return. When are you expecting a refund? I'm disappointed that you haven't made a payment. If I don't receive a payment from you and information on when you will get your tax refund, then you'll put me in the position of having to file a motion to withdraw, which I will file with the court on May 5th at the close of business. I realize that you got a lot going on, but I just can't continue this way. Next email is another email to my ex. I need for you to make a substantial payment on your bill and to arrange for a monthly payment of $200. This is pretty reasonable. I mean, she's asking for $200 a month to continue to represent her. This is not coming off to me as a greedy attorney. She's just saying, hey, I need you to at least pay something. And I guess a substantial payment is going to be the tax refund. The last payment she showed was November of last year. The balance is $12,000. There's a hearing in June, and she can't continue to represent her unless she is paid. That's it. No more emails. Next document, request for submission by who? Looks like my attorney filed a request for submission on a stipulation. Okay, so it's an accompanying stipulation, so it'll probably be the next document that we look through. It should be here. Okay, I'm taking a look now, and it looks like it's 1, 2, 3. It looks like it's 4 videos ahead. I'm not going to, rearrange these documents. We all know what a request for submission is, guys. This is probably the 50th one we've seen so far. If you need to learn more about how the request for submission works, just take a look at the video titled Request for Submission. Next document is a certificate of service under Rule 5 indicating that this was mailed to my ex's attorney. We have another request for submission, only this one was filed by my ex's attorney, not by my attorney. And this is my ex's attorney submitting to the court the motion for order to withdraw as the attorney of record. This is probably unopposed, I imagine. We're going to continue to look through these documents and hopefully it'll pop up. But I don't recall us, opposing my ex's attorney's withdrawal. So even if it wasn't filed, for sure, we just, we didn't really have an opinion on it. If she wanted to get out of the case, fine. Get out of the case. The only thing that I can think of to tell you guys as a piece of advice is if something like this is filed at the last minute right before the hearing, there's a possibility that it can trigger a continuance. So you may have a basis to oppose your ex's attorney withdrawing from the case if it's going to trigger a delay in the case and your child is suffering, which most of the people on this channel have children who are suffering, or at least they feel that's the case. Under these circumstances, we didn't have an attorney for a few months, so this isn't something that would be a big deal to, just kind of allow to happen. Rule 5, certificate of service. My ex's attorney is indicating that she served my attorney electronically and that she mailed this document to my ex. Here we have, okay, so I was right. We did file a notice of non-opposition. So my attorney here is filing a notice of non-opposition to let the court know that the motion that my ex's attorney filed is not going to be opposed. Why would she do this? To be nice, it's going to let that lawyer know, it's going to let the judge know that we didn't accidentally forget to file an opposition. It was deliberate. We don't have any opposition to that motion. And it also allows my ex's attorney to file the request for submission immediately. She doesn't have to wait for all the time to lapse. And what I'm talking about is the computation of time. If you need to learn a little bit more about the timelines and the deadlines, take a look at that video, computation of time. But by filing this notice of non-opposition, that immediately lets my ex's attorney file the request for submission to get that in front of the judge as soon as possible. Here we have the certificate of service indicating that this document was served upon my ex's attorney under Rule 5. Here we have the application for setting, and here we are indicating that the evidentiary hearing has been scheduled for what day? The 27th of August at 1:30. So this is not when it occurs, so don't get too excited. It gets continued one more time. It's going to get heard, I think, sometime around November 4th. But we have at least set the date of the hearing, the evidentiary hearing, on that motion to modify child custody. And it looks like both my attorney and my ex's attorney were present at the setting. Here we have a stipulation. This is a stipulation that was signed by both of our attorneys and approved by the judge. This is, let's see here, first paragraph. I, through my attorney, Marilyn York, and my ex, through her attorney, Kathrine Berning, hereby stipulate and agree as follows. Number 1, the hearing on the motion to modify custody set for June 17th, 2014 is to be vacated, and the parties agree to reset the hearing within 10 days of the entry of this order. Okay, so that's, okay, I don't think this is the only time it gets continued. I think it gets continued again one more time. Anyway, let's go ahead and continue. The witnesses, Leah Shebler and Dr. Molina, are allowed to testify telephonically at the hearing on the motion to modify child custody. This didn't end up happening for both of them. Dr. Molina does appear in person to testify. Leah Shebler, however, does appear by telephone to testify, and that's because she moved to Las Vegas at the time that the hearing was set. And that's it. The attorney is just agreeing as to how a witness is going to testify. Here we have the order granting, oh wait, there should be an approval by the judge. Yeah, right here. District Judge Chuck Weller is signing this document to approve it. Order granting withdrawal of counsel. So the judge is indicating that on May 6th, he has reviewed, or no, wait, when did he? On May 12th, he has entered this order. So he's just referring to the May 6th document that was filed by my ex's attorney. Okay. He's indicating that he has reviewed my ex's attorney's motion to be relieved and he is citing my ex's failure to comply with the agreement pertaining to the payment of attorney fees. He cites the rules of civil procedure, specifically 1.16 subsection 6, that allows a lawyer to withdraw when representation would result in an unreasonable financial burden on the lawyer. Next assertion is that good cause appearing pursuant to the Nevada Supreme Court rules and the Washoe County District Court rules. So this is a local rule and a higher up Supreme Court rule. My ex's attorney, Kathrine Berning, is hereby relieved as attorney of record for my ex. She is gone. She is moving on. We will not see her again in this case. This is the end of this attorney's involvement in this case. Next assertion is, or next paragraph is that all further pleadings and correspondence are to be sent directly to my ex. Certificate of mailing under Rule 5, the judge is indicating that he served my ex at her address by mail, and both my attorney and my ex's attorney through the electronic service process. Here we have the Notice of Entry of Order. This is a document that has been entered by my ex's attorney. It is going to trigger the time for my ex to file an appeal. I don't even know if these orders are appealable. They probably aren't. In any event, you can take a look at the video Notice of Entry of Order to learn more about why this document needs to be filed and why it's more than just a plain notification, hey, an order was entered. There's more behind this document. It triggers the deadlines for filing an appeal. It's important. And then we have Rule 5, Certificate of Service, indicating that this document was mailed this document was served electronically upon my attorney and that it was mailed to my ex personally. Going into the aftermath, I filed, it looks like, wait a minute, I filed one request for submission, one stipulation, that's 2 documents. It looks like just 2 documents. And my ex's attorney I filed 2 documents that were free, so I incurred $0 in costs. My ex's attorney filed 1, 2, 3 documents, it looks like. Looks like 4 documents from my ex's attorney. All of those were also free filings, however, so she incurred $0 in costs as well. My attorney would have reviewed the motion seeking leave of the court, probably very briefly. She did have a discussion over the phone. She also did have to prepare the stipulation, and that stipulation is probably going to be really one of the things that ends up taking more time. Couple of requests for submissions. I think I'm going to put those each at 5 minutes. So we're looking at 10 minutes, the motion at 5 minutes. So looking at 15 minutes there total so far. Then the setting itself, that would have taken some time for that lawyer. That's probably another 15 minutes at least. So we're looking at 30 minutes there. The notice of non-opposition, that's another, it's hard to say, 10 minutes probably. I don't think I want to say 5 minutes for that notice of non-opposition because it wasn't boilerplate. So we're at 40 minutes. Then we have both of the order from the court. I'm going to put that at 5 minutes. And then the notice of entry of order, another 5 minutes. So 50, we're roughly at an hour. And then the stipulation itself, plus the communication back and forth with the attorney, that's going to be at least 30 minutes. Luckily, it's short. Otherwise, it would take even longer than that. So I think an hour and a half at $500 an hour, that's going to come to $750 in attorney fees for me. My ex's attorney would have had to prepare the motion to withdraw. That is going to be, and then there's, of course, some email communications to my ex. To say that was 30 minutes is cutting it close. That might be a 45-minute document. Let's go ahead and say 45 minutes, but when we combine in both requests for submissions, and then she's going to have to communicate with my attorney on the stipulation and sign it. That's going to be another 15 minutes. I think that an hour, and then she still has to review the order and enter the notice of entry of order. I feel like an hour and a half for my ex attorney is also reasonable. At the rate of $250 an hour, that's going to come to $375 in attorney fees for my ex. As with our previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.